Hello. In this video, we will be defining arbitration and walking through a court-annexed arbitration scenario. Let's start with some basic definitions. First, it's important to understand that arbitration is a type of alternative dispute resolution, better known as ADR. When effective, ADR can settle legal disputes faster and at a lower cost than a traditional trial. A key point to understand is that arbitration is overseen by a neutral third party, which may be a single arbitrator or a panel. Much like a traditional trial, parties have the option to have attorneys represent them. Finally, the process is less formal than a trial. However, it still holds the same respect in the legal system. There are two types of arbitration. The first type is court-annexed. This means arbitration was ordered by a judge and a mandatory process. However, not all Illinois counties have mandatory arbitration, and for those that do, the rules vary by county. The next type is private arbitration. As the name suggests, this is when parties in a legal dispute choose to hire a private arbitration firm to conduct the arbitration in hopes of avoiding a potentially lengthy and expensive traditional trial. Unlike with court-annexed, this option was chosen by the parties, not court-ordered. Let's take a look at what a court-mandated arbitration might look like. The plaintiff, Kai James, is suing the defendant, Jesse Ellis, for $10,000. Let's hear what they have to say.
About 2 years ago, Mr. Ellis rear-ended me, and since then, I've been dealing with ongoing neck and back issues. The medical bills have piled up, and I've missed a lot of work because of it. So I decided to file a lawsuit to try and recover the money I need to cover my medical expenses.
While I acknowledge Miss James and I were involved in a minor traffic incident, which admittedly was my fault, her medical reimbursement requests didn't arrive until 18 months after the accident.
My name is Nadia Patel, and I will be representing Miss James. Because the accident took place in a county that mandates arbitration for cases below a certain dollar threshold, we must first go through arbitration to see if a resolution can be reached before proceeding to trial.
Hello, I'm Ben Grant, representing Mr. Ellis. Since he lives over an hour from the accident site, both parties have agreed to a remote arbitration hearing. As Ms. Patel mentioned, this county requires arbitration, so a panel of 3 arbiters will review the case and issue a non-binding decision, meaning that if either party disagrees, they have the right to take the case to trial.
Good morning and welcome to this arbitration hearing. My name is George Alpine, a retired judge, and I will be serving as the lead panelist today, along with my fellow panel members, Ms. Amin and Ms. Sandholm, who are both practicing attorneys. This hearing is for case number 2024 AR00123 involving plaintiff Kai James and defendant Jesse Ellis with an amount in controversy of $10,000. The purpose of this arbitration is to provide both parties with an opportunity to present their case in a fair and efficient manner. Before we begin, let's confirm that both parties are present. Plaintiff, please state your name for the record.
Hello, I am the plaintiff, Kai James.
And I am Nadia Patel, Miss James' attorney.
Thank you. Defendant, please state your name for the record.
Hello, I am Jesse Ellis.
And I am Ben Grant, Mr. Ellis's attorney.
Welcome, everyone. Now, I'd like to review a few procedural guidelines to ensure a smooth hearing.
At this point in the hearing, the lead panelist will go through various procedural instructions, such as muting and speaking, recording and confidentiality, presentation of evidence, objections, and speaking order.
Does anyone have any questions about the process before we begin? If not, we will start with the plaintiff's opening statement. Ms. Patel, you may proceed.
Thank you, Mr. Alpine. On the afternoon of March 24, 2023, Miss James was at the intersection of Elm and State Streets.
Each party then presents their case, beginning with the plaintiff, followed by the defendant. This includes testimony, supporting documents, and any relevant evidence. Throughout the hearing, the arbitrators may ask clarifying questions to ensure a full understanding of the case. After both sides have presented their arguments, they are given an opportunity to make closing statements. Then the lead panelist will close the proceedings.
Thank you all for your participation today. We have now heard from both parties, including opening statements, the presentation of evidence, and closing arguments. The panel appreciates your cooperation in maintaining a professional and orderly proceeding. The arbitration panel will now review all presented evidence and testimony before reaching a decision. This decision will outline our findings and any awards or resolutions determined. If either party does not agree with the panel's decision, you will have the option to reject the award and proceed to trial, as per the rules of mandatory arbitration in this jurisdiction. The specific process and timeline for doing so will be included in the decision you receive. Again, we appreciate your time and cooperation throughout this process. This hearing is now concluded. Thank you.
While this video provides a general overview of the arbitration process, it's important to remember that every case is unique, and there may be additional steps and legal considerations depending on the situation. In summary, arbitration is designed to offer a fair, efficient, and accessible way to resolve disputes. But if you're involved in a case, be sure to review the specific rules and procedures that apply. We hope this video has helped simplify the basics of arbitration. Thank you for watching.